Good afternoon, and welcome to the McGuireWoods Securities Compliance and Disclosure Update. My name is Katie DeLuca, and I am a Securities and Capital Markets Partner in the firm's Richmond office, and I will be serving as moderator for today's program. In case you're not familiar with us, McGuireWoods is a full-service law firm with more than 1,100 attorneys and 22 worldwide offices. Our more than 50 securities and capital markets lawyers represent some of the nation's largest business and financial institutions. We regularly serve as counsel in public and private securities offerings and help clients understand and address unique securities, compliance issues, and reporting requirements. Recently named Banking and Finance Law Firm of the Year by U.S. News, McGuireWoods regularly ranks among the top leading law firms in various capital markets league tables. Before we begin today's program, I would like to call your attention to the Q&A icon in the lower left-hand corner of your screen. Please use this widget to submit questions you may have for our panelists at any time during the program. We will do our best to address your questions in the time allotted. However, if we are unable to do so, we will follow up with you by email. You will also find a number of additional resources along the bottom of your screen, which we encourage you to explore during the presentation. Notably, the meetings materials folder includes a copy of today's presentation slides. So without further ado, allow me to introduce our first two speakers. Emily Gordy and Natasha Cooper. Based in our Washington, D.C. office, Emily is a partner in our Government Investigations and White Collar Litigation Group and advises clients as they navigate the complexities inherent in the securities regulatory environment. Previously, she held senior executive roles during her 14-year career with FINRA Enforcement, and also served as Chief Regulatory Counsel for the nation's largest independent broker-dealer. Natasha is an associate in our Complex Commercial Litigation Group and is based in our Atlanta office. She has a robust litigation and regulatory practice representing financial institutions, broker-dealers, and investment advisors in federal and state courts. Emily and Natasha will be discussing the SEC's crackdown on tech system compliance today. Emily and Natasha.
Thank you. Both of us really appreciate the opportunity to present to this group today. Natasha and I are going to discuss the SEC's focus, or as you see from the title, the crackdown on tech system compliance. While much of the information we're discussing today pulls from the financial services regulatory space, the topics that we're going to cover, the pitfalls, and the lessons learned really do apply equally across all practice areas. It's an increasingly complex world, and technology is really the linchpin for getting the job done. But as you'll see from our discussion as we go on, there are challenges with implementing tech systems, and we're going to share some best practices in order to navigate through those challenges. We're focused today on the securities regulators, the SEC and FINRA. We're going to cover an overview of the regulatory focus, examples of how technology is leveraged to assist in complying with regulatory requirements, when technology or its implementation fails and what can happen, and then lastly talk about some key regulatory guidance on best practices. So with that, I'm going to turn it over to Natasha, who is going to walk us through each of those areas.
Thank you, Emily. So as Emily mentioned, today we're going to cover a broad array of how technology can be used for market participants. Particularly what we've been seeing is that the SEC as well as regulators broadly are starting the conversation. They're paying attention to how technology can be leveraged, how it can be used to better help the end investor. But they're also paying attention to see if those technologies that are being implemented are reasonable, if they're compliant, and if they're doing as what they're intended to do. Now, as mentioned, the SEC and FINRA, as Emily had mentioned, has made technology a priority. Recently, in 2019, we saw FINRA actually release what they call their RegTech report in their examination priorities. They talked about how RegTech can be used and what they're doing to develop that conversation and what they're expecting to see with broker-dealers and what they're expecting to see in the future in 2020 as well as going forward. Now, what we can talk about is going to kind of fall into two umbrellas with RegTech. Particularly one is how institutions can use technology, as we said, to better help investors, but also two, we're going to look towards the compliance area as technology working as it's intended to work, or is the compliance aspect of the broker-dealer or the market participant being better helped by having technology in place? Now, with anything that is innovative, there's room for growth. And what that means is that there's a learning opportunity, and the goal with any enforcement action is to be a spectator to that lesson and not a part of the lesson. So what Emily and I are hoping to teach you all today is basically some best practices as well as going through some cautionary tales of how technology can be used and how you can prioritize it in your practice. How technology can be used. So technology is actually becoming more and more common within the financial industry. In a 2018 survey by Thomson Reuters, 52% of compliance and risk professionals stated that RegTech solutions affected how they manage compliance in their firms, with 17% already saying that they have implemented one or more of the RegTech solutions that we're going to discuss today. Now, the global demand for RegTech compliance and governance software is expected to reach $118.7 billion by 2020. That's with a B, billion. Now, this is a very lucrative industry, but why? How can we use technology to help the financial services industry? Well, there's 5 real areas that we can talk about how technology is leveraged. Number 1 is regulatory intelligence. That's focusing on identification and interpretation of changes to applicable rules and regulations. That's to update your firm's compliance operation, as well as using it to help cross-see with natural language processing and machine learning to read and interpret new and existing regulatory requirements. With using this, you can basically create gap analyses. That basically uses natural language processing and machine learning to read and see what it is that your system is not doing. Now, that can be used to identify, as we said, potential gaps, as well as deficiencies within your organization's compliance program. One area where we've seen this actually be implemented already within the UK, the Financial Conduct Authority for the United Kingdom has offered an initiative to make their rules more machine readable. That allows financial services institutions to then take these rules that are machine readable, implement them, whether that is with artificial intelligence or natural learning processes, to basically go through and see how their rules and regulations can be compliant with new rules and regulations as they come out. A second area where we're seeing technology be used and leveraged is reporting and risk management. And now that's more common with data aggregation, risk metrics, creations for regulatory reporting, internal models, as well as using it to basically create capital and liquidity models for regulators. Another area which we've seen it is risk management and customer identification. Now, this is just simply looking for more effective solutions. With risk management and customer identification, it's actually a fun area for financial services to look at what the broader market is doing. Technology is not something that is specific to financial services, but we're seeing it become more and more common in our day-to-day use. I know Emily and I were just discussing that on her way here to Atlanta, she actually used Clear, which is something that uses biometrics. And it's something that we are seeing more and more with AML requirements, KYC issues with FINRA. So biometrics can be used to help identify your customers in better ways, as well as creating effective solutions to avoid any pitfalls. However, there's also issues with that, as we'll discuss later on. And another area that we're seeing it is with surveillance and monitoring. Now, this refers broadly to market surveillance and conduct monitoring, such as monitoring traders, registered representatives, employees, and customers for regulatory purposes, as well as market participants using cloud computing, artificial intelligence, machine learning, and big data analytics to obtain more accurate alerts and enhance compliance and supervisory staff efficiency. Now, the goal with surveillance and monitoring is to move from a rule-based system to predictive risk-based surveillance models. Ultimately, using technology can help you with your surveillance and monitoring to actually predict where certain risks may be, where the pitfalls are, and actually processing that data that you may be storing to better help the end consumer, which is the investor. Now, with all these, there's one thing that comes to mind. We can implement technology, we can put it in place, but how do we ensure that what we're doing is okay with the regulators? As stated at the forefront, FINRA and the SEC has already began this conversation. They are looking to see that technology that is in place is actually compliant. Well, what that means is it's a reasonable standard. Regulators are not expecting perfection, as this is a growing area that is new for everyone. So essentially, the reasonable standard, whether that's in the Investment Advisor Act or FINRA rules, looks directly towards whether or not the processes in place are reasonable, and that's supervisory policies and procedures, as well as supervisory policies and procedures that relate to end investors. With what's reasonable, it's easier to define it based off of what is not reasonable and what cautionary tales come from FINRA AWCs as well as SEC settlements. Now, it's always, hindsight is 20/20, and we look back and we see typically what happens is firms do put, the bells and whistles in place. They have everything in which they think is helpful in terms of technology and automated systems, but the issue becomes whether or not those systems are working as intended, whether or not those systems are creating new pitfalls that they did not anticipate. And what FINRA and the SEC has done is really kind of give us, I would say, a streamline of cases where they're saying the common theme is make sure it's working as intended. Make sure you're checking it. Make sure you're going back to see that what you actually had in place, as we said, is performing as it should be, and not waiting years and years before realizing that problem was occurring. FINRA has brought numerous enforcement actions within the last couple of years, basically highlighting these issues. And when firms put these procedures in place, while they might sound reasonable at the outset, they aren't actually performing as intended. And that might just be from, lack of knowledge, not having the right protocols in place, supervisory systems in place, and people who are actually paying attention to say, you know what, we should have tested this prior to implementing it. Or maybe we should do independent testing, independent reviews outside of the systems that we do have in place. Now, one of these that we have here highlighted was actually back from 2008. This was a case where 8 years had went by, and it was in 2016 that FINRA basically realized that this firm had a procedure in place that was not being tested. They had the automated systems. They had all the bells and whistles, but there were design flaws. There was coding data errors in the electronic systems that they inherited from a legacy firm that they took over. They ultimately failed to promptly obtain and maintain physical possession of control, creating deficits in securities that they were held by their customers. But essentially, as FINRA outlined, it's a reasonable procedure we just asked for. We're not asking for perfection. We're just asking you to test your segregation process, test your supervisory process, make sure that what you're actually putting out there is doing as it intends to do. The SEC has similarly said the same thing as FINRA with their cautionary tales. We recently saw a case come out last year, which was one of several, where we see broker-dealers as well as investment advisors being dinged for millions of dollars for systems that, actually encourage and leverage technology. However, as we stated, the technology was not performing as intended. And now the issues became one, they had an automated system and a manual system, which is great, As we will discuss in our best practices, it's not okay to just rely upon these automated technology systems. As fancy as they sound and artificial intelligence sounds great, but you do need to also use that as a complement to what you already have in place in your manual reviews. In this particular SEC settlement, the SEC highlighted that the automated system was where it failed because no one was actually checking to see the misappropriation was occurring. So for years at a time, there was misappropriation occurring up to $1 million in aggregate was taken from clients' accounts, but it was because the automated tools did not effectively flag unauthorized address changes for clients. So having those systems in place can be helpful. However, if you're not having supervision of those systems, it actually tends to hinder the process in what you're trying to accomplish. Now, as we discussed with the cautionary tales, the rise of RegTech and FinTech brings new challenges, particularly with RegTech and trying to enhance compliance. So specialized artificial intelligence knowledge is sometimes required for these areas. Whether that's bringing in a consultant, having appropriate training, artificial intelligence, RegTech, it's an area that's brand new to many of us. It's an area that is ever growing, and having the right knowledge base is kind of crucial in this area, particularly when you're talking about compliance systems and speaking with regulators to ensure and provide them with the comfort that your system is reasonable. As we mentioned, auditing your methodology and your logic that you're using. Having the algorithms in place, that's wonderful, but does your algorithm actually perform as intended? Is it creating false positives? These are all areas that you have to be mindful of, and whether that's independent auditing or auditing periodically, there needs to be some kind of testing in place just so you can say when the darkest day comes to the regulator, you know, we did do testing every couple of months and we did do independent audits, and this was something that we did not anticipate, and they just want to see that there was some reasonable measure in place. And then the third issue that we're seeing is cybersecurity and data-related risk. So with big data and artificial intelligence, you're basically seeing a lot of this data being collected, whether it's on independent systems or internally. So you can farm out and bring on vendors to collect this data for you, analyze it, and provide you with risk assessments and better, information for your clients. But at the end of the day, this is still client information, and you cannot delegate your duties as to what you owe to the regulators. And regulators have been very, very vocal to the fact that if you have vendors, whether or not it's collecting the data outside or internally, please be mindful of the fact that you have an obligation to protect that through the SEC as well as FINRA. So update your privacy notices. Whenever you do share information and collecting data, please let clients know that you have information sharing policies in place. Cybersecurity is a priority for the SEC, and they have talked about with moving towards automated systems, you have these new access points for threats. So you have to be mindful of when you do collect data to actually not create more risk for yourself as well as for third-party vendors. So just keep in mind and comply with, SEC Reg SP, and just think about the fact that, having data, biometrics, all these things, it's great, bells and whistles, but at the same time, there are new risks associated with it, and just update those WSPs to make sure you're compliant with what is going on.
Thanks, Natasha. I'm going to wrap it up by highlighting just a couple of the best practices. We have a number of them listed on the deck. But rather than taking time to go through them all, I wanted to highlight just a couple. First is make sure that you have the right people, the right stakeholders at the table when you're either designing and implementing or discussing changes to systems. If it's just technology at the table, then in those situations, more often than not, you're going to have compliance or legal issues down the road. Everybody who has a stake needs to be there. Secondly, for data quality risk management, make sure that, as Natasha was saying, periodic testing of the programs to make sure that you're getting accurate, complete, and consistent results. Also, the biggest thing is that practice highlights issues early. Many of the cases, Natasha mentioned one where technology gaps have gone on for a decade, 5 years, 6 years, longer, and those are the issues where it's tough for the regulators to not bring an enforcement action in those situations. So that kind of quality risk management will definitely mitigate issues there. And lastly, for resolving issues, be proactive, document what you're doing when it was identified, steps you're taking to stay on top of it, to get in front of it and to resolve it. Have an escalation process to raise and address issues, and also ensure that there's ownership and accountability. To the extent that often we've seen situations where problems arise because the issue's identified, people wring their hands, they try to resolve it, but then proactively actually driving to a resolution doesn't happen because there's no ownership. So again, there are a couple of other best practices noted. I think they do speak for themselves. So on that note, we'll turn it back. Thank you.
Thank you, Emily and Natasha. Our next presenter today is Barlow Mann. Based in our Charlotte office, Barlow is an associate in the Securities and Capital Markets Group. Barlow's experience includes representing public and private companies in securities transactions and other general corporate matters. Today, Barlow will be discussing internal controls over financial reporting and material weaknesses. Barlow?
Thank you, Katie. I'm looking forward to talking today about internal controls over financial reporting and a handful of recent SEC enforcement actions relating to those requirements. On January 29, 2019, the SEC announced that it had settled charges against 4 public companies for failing to maintain internal controls over financial reporting for 7 to 10 consecutive annual reporting periods. I have here on the slide a couple of quotations from SEC staff from the press release that was put out in connection with these settlements. I think these quotations really highlight the SEC's kind of renewed focus on these requirements and the purpose that they're designed to serve. To give some background on these cases, which we'll talk more about later in the presentation, the circumstances were particularly egregious. However, the fact that the cases were announced together seems to indicate that the SEC is sending a message to public companies generally, a fact that's been noted by a number of commentators. As the presentation proceeds, I'll present a high-level overview of the SEC's rules relating to internal controls over financial reporting, and then touch on the recent cases and key takeaways for companies that are subject to the internal controls requirements. A quick important disclaimer here is that this really will be a high-level overview, and it's not intended to be comprehensive since the topic of internal controls is very complex and has been written on extensively. So, to give a quick overview of the statutory and regulatory requirements, as described by the SEC, an overall purpose of internal control over financial reporting is to foster the preparation of reliable financial statements. Section 404 of Sarbanes-Oxley provides the background statutory requirements for the SEC to establish rules relating to internal controls. This Section 404 does not actually define internal control over financial reporting. I'll note here that Section 404 also requires each registered public accounting firm that prepares or issues an audit report for a public company to attest and report on management's assessment of internal controls. And the SEC's rules expound on this requirement. However, I won't go into detail on these rules because they aren't implicated by the recent SEC cases. But I will point out that following changes implemented as part of Dodd-Frank and the Jobs Act, the auditor attestation requirements do not apply to emerging growth companies or companies that are not accelerated filers or large accelerated filers. Rules 13A15 and 15D15 under the Exchange Act and Regulation SK Item 308 are the SEC's main rules governing a public company's and management's responsibilities with respect to internal controls over financial reporting. The internal control over financial reporting requirements under these rules are generally subject to a one-year grace period for new public companies. So companies aren't required to comply with them until after they filed their first annual report. In connection with the following slides, I'll discuss many elements of Rule 13A15 and 15D15 requirements in greater detail. But before I do that, I'd like to note that internal controls over financial reporting should not be confused with disclosure controls and procedures, which are also addressed by the same rules but comprise a different set of requirements. And there's no grace period for complying with the disclosure controls and procedures rules. So, internal control over financial reporting is not defined by Section 404 of Sarbanes-Oxley. Instead, it's defined by the SEC in Rules 13A15F and 15D15F. The slide here includes the SEC's complete definition of internal control over financial reporting. I will read just the first paragraph and then linger for a moment on a few features of the definition. The term internal controls over financial reporting is defined as a process designed by or under the supervision of the issuer's principal executive and financial officers or persons performing similar functions and affected by the issuer's board of directors, management, and other personnel to provide reasonable assurance regarding reliability of financial reporting and the preparation of financial statements for external purposes in accordance with general accepted accounting principles. It includes certain policies and procedures which are listed on the slide. One feature to note here is that internal controls over financial reporting must be designed by or under the supervision of the principal executive officer and principal financial officer. In addition, note that these procedures are required to be effected by the issuer's board of directors. This requirement differs from the rules relating to disclosure controls and procedures, and I think implies that the SEC expects that the board will be more directly involved in connection with internal controls over financial reporting. Finally, note that these requirements relate to reasonable assurance and providing a reasonable amount of detail, not absolute assurance or absolute levels of detail. The SEC has noted that the use of reasonable assurance and reasonable detail here relate to similar language in the Foreign Corrupt Practices Act, which define them as such level of detail and degrees of assurance as would satisfy prudent officials in the conduct of their own affairs. The SEC comes back to this standard of reasonable assurance in 2005 and 2007 guidance that it issues on internal controls, in which the SEC emphasizes what it calls a top-down, risk-based approach to internal controls over financial reporting. I'll discuss this in more detail a little bit later on, but in essence, the SEC has communicated that, has emphasized that these procedures are designed only to be reasonable, not to be absolute, and companies shouldn't get too bogged down in the details of analyzing and assessing each and every control that they have. Now I'll discuss for a moment the annual internal control report that's required by Regulation SK Item 308. Item 308 sets out the SEC's disclosure requirements with respect to management's report on internal controls over financial reporting. As I mentioned before, these requirements don't apply until the second annual report a company files with the SEC. In addition, the SEC has clarified that a company's principal executive officer and principal financial officer may, in connection with filing the company's first annual report, modify the certificates required by Rules 13A14 and 15D14 to remove references to internal controls over financial reporting. Once Item 308 applies, four elements comprise the required disclosure. The first element is a statement of management's responsibility for establishing and maintaining internal controls over financial reporting. In practice, this statement usually takes the form of a boilerplate recitation of the rule. The second element is a statement identifying the framework used by management to conduct the required evaluation of effectiveness of internal control over financial reporting. Under Rule 13A15A, management's evaluation is required to be based on a suitable, recognized control framework that has been established by a body or group that has followed a due process procedure, including broad distribution of the framework for public comment. The SEC noted that the COSO framework, as well as the frameworks published by the Canadian Institute of Chartered Accountants and the Turnbull Report published by the Institute of Chartered Accountants in England and Wales, are examples of suitable frameworks. The third element of the annual internal control report is a statement of management's assessment of the effectiveness of internal control of financial reporting as of the end of the company's most recent fiscal year, including a statement as to whether or not internal controls are effective for the year. I will cover this requirement in more detail in just a moment. The fourth and final element is a statement that the registered public accounting firm that audited the financial statements included in the annual report has issued an attestation report on management's assessment of internal control over financial reporting. Emerging growth companies are exempt from this requirement and is generally limited to accelerated filers and large accelerated filers. However, if a company that is not otherwise subject to this requirement includes an auditor's attestation report in its filed annual report, it must comply with this element of Item 308. Okay, now I'll discuss in a little bit more detail the third element of the annual report on internal controls over financial reporting, which is the management's assessment of the effectiveness of internal controls. As I mentioned before, the annual report is required to include a statement of management's assessment of the effectiveness of internal controls as of the end of the company's most recent fiscal year, including a statement as to whether or not internal controls are effective. Management may not qualify this assessment, for example, by saying internal controls over financial reporting are effective, subject to certain qualifications or exceptions. But management may state that internal control is not effective for specific reasons. With a couple of exceptions, this seemed to be the general approach adopted by companies that were charged by the SEC. They simply continued to file reports disclosing that their internal controls over financial reporting were not effective. It's also important to note here that filing a timely report that includes a conclusion that internal controls are not effective will not affect an issuer's eligibility for Rule 144 or short-form registration statements on Form S3 or S8. The SEC has confirmed this in informal guidance. As part of their assessment on internal controls, management must disclose any material weaknesses in internal controls that they identify. I'll discuss the definition of material weakness and related disclosure requirements in a bit more detail shortly. Management is not permitted to conclude that internal control is effective if there are one or more material weaknesses. The rules do not specify the procedures to be performed in an evaluation of internal controls, but the SEC has stated that inquiry alone generally will not provide an adequate basis for management's assessment. In their adopting release, the SEC clarified this statement to say that management are not personally responsible for undertaking all of the duties and actions necessary to complete the evaluation, but they must at least supervise people who undertake those activities. Finally, a couple of additional points. Management cannot delegate its responsibility to assess its internal controls over financial reporting to its auditor, and companies are required to maintain documentary evidence to support management's internal control report. Shortly after the SEC's final rule on management's report on internal control over financial reporting came into effect in August 2003, the SEC held a number of roundtables and other public events and invited written submissions from the public regarding its internal controls rules. According to the SEC, the feedback made clear that companies had realized improvements to their internal controls, but also identified implementation areas that needed further clarification to reduce unnecessary costs and other burdens without jeopardizing the benefits of the new requirements. This slide summarizes at a high level some of the SEC's guidance in the wake of these public consultations. Again, the SEC's guidance is much more detailed that can be covered during this presentation and is highly informative. I encourage you to consult this guidance for more information if you're interested. I think the entire slide here can be summarized by the first sub-bullet, which is a top-down risk-based approach. The SEC uses this phrase constantly in its informal guidance in 2005 and 2007, and what this means is rather than starting from the bottom and identifying each and every control a company has and analyzing and testing those controls, the company should start from the top and identify the processes and classes of transactions that are most likely to have a material impact on the company's financial statements. From there, the company can proceed on a risk-based basis or a risk-weighted basis to test and analyze its most important controls and procedures. The SEC also focused on reasonable assurance rather than absolute assurance. Okay. This slide discusses some of the SEC's guidance regarding disclosure about material weaknesses. All of the companies that were charged by the SEC were including disclosure responding to these requirements in their annual reports. So this is of particular interest here. As defined by the SEC, a material weakness is a deficiency or a combination of deficiencies in internal controls such that there is a reasonable possibility that a material misstatement of the registrant's annual report or interim financial statements will not be prevented or detected on a timely basis. The Commission guidance of June 2007 provided a little bit more background on this statement. In essence, the SEC encourages issuers to disclose not just the fact that they have a material misstatement, but to provide additional background information that will be helpful to investors in analyzing how important it is and whether or not the material weakness might be pervasive throughout their internal controls over financial reporting. In addition, the SEC noted that when a company is required to restate previously issued financial statements in order to correct a material misstatement, the company should consider whether its earlier disclosures relating to the effectiveness of internal controls over financial reporting for the period to which the restatement relates should be modified or supplemented to prevent such disclosures from being misleading in light of the restatement. And they also would need to disclose any material changes to internal controls as required by Item 308C of Regulation SK. Okay, moving on now to a summary of the recent enforcement actions by the SEC. Charges were brought against 4 companies for failing to maintain internal controls over financial reporting for 7 to 10 consecutive annual reporting periods. 2 of the companies also failed to complete the required evaluation of the effectiveness of internal control over financial reporting for 2 of the annual reporting periods. These companies continually disclose material weaknesses in internal controls involving certain high-risk areas of their financial statement presentation and took months or years to remediate their material weaknesses after being contacted by the SEC. It is important to note here that many of the companies charged actually were undertaking some remediation efforts, including in some cases hiring external advisors. However, the SEC viewed these remediation efforts as insufficient. In one case, the SEC criticized the company for boilerplate disclosure, offering, quote-unquote, no information as to the specific material weaknesses observed. Penalties included fines of up to $2,000 and, in one case, an undertaking requiring retention of an independent consultant to ensure remediation of material weaknesses. Some of the key takeaways from these enforcement actions are as follows. The SEC does not view disclosure alone as a sufficient response to material weaknesses in internal controls, in particular when a company repeatedly discloses material weaknesses. The SEC expects to see, quote-unquote, meaningful remediation. In addition, the SEC disapproves of boilerplate disclosure with respect to material weaknesses. Moreover, repeatedly including the same description of a material weakness, as some of the companies who were charged by the SEC did, may indicate a lack of efforts to remediate. The SEC may bring enforcement actions solely for violations of the requirement to maintain internal controls over financial reporting, even in the absence of other misconduct or a restatement of prior disclosures. In the past, the SEC's charges for violation of the maintenance requirement have often accompanied charges of other misconduct or were related to significant restatements of financial results. So, in 2 of the cases here, when the SEC's charges related solely to the requirements to maintain internal controls, that was viewed by many as a signal that the SEC may be renewing its focus on this requirement. While there's no bright line test for how long is too long to remediate control deficiencies, companies should act quickly and efficiently. As I mentioned before, some of the companies here were working to remediate their issues, but the process was simply taking too long, and the SEC ended up bringing enforcement actions against them. Finally, these enforcement actions should be viewed in the context of some other actions by the SEC recently. The SEC has been focusing recently on internal controls violations, including in a September 2018 settlement that was based in part on violations of internal controls rules, a September 2018 settlement with another company relating to the lack of disclosure controls and procedures for executive tweets, an October 2018 report on recent cybersecurity incidents and related internal accounting controls and requirements, and finally, a December 2018 speech by SEC Chief Accountant Wesley Bricker, who was also involved in the recent cases. Taken together, I think all of these events and episodes represent that the SEC is renewing its focus on its rules relating to internal controls, and this should be an important area to watch for companies going forward. Thank you very much.
Thank you, Barlow. Presenting next is Nova Harb. Nova serves as counsel in the Securities and Capital Markets Group and is based in our Jacksonville office. Her practice includes business and corporate law with an emphasis on federal and securities laws, mergers and acquisitions, and corporate governance. Today, Nova will be discussing current BlackRock and State Street priorities.
Thanks, Katie. In the last several years, it's become customary for institutional investors to provide annual letters to their portfolio companies and other stakeholders, providing the investors' views about companies' long-term strategy, messaging, goals, shareholder engagement, and similar topics. Over the years, these letters and messages to companies have become more specific in the types of causes that each investor focuses on, and in turn what the investor expects the company to focus on. We are also starting to see that investors have become more sophisticated in their expectations from companies. It's no secret that institutional investors have been trending in focus on environmental, social, and governance factors. This has been exacerbated by fundamental economic changes and mistrust in the government, leading the public to increasingly look to companies to address pressing social and economic issues. These issues range from protecting the environment, to retirement, to gender and racial inequality, among other things. Public pressures on corporations are building faster and reaching further than ever before, and this is being fueled in part by social media. As companies hit record levels of engagement, they are bringing together teams of legal, finance, ESG, and investor relations focus groups, as well as members of management and senior management and directors to develop materials and messaging intended to demonstrate advanced levels of engagement and to evidence that they're listening to their investors' concerns. Today I'm going to focus on two investors, BlackRock and State Street, who both released their annual letters in January and shared similar views. BlackRock's letter reiterated its focus on the need for corporate purpose and how purpose informs a company's long-term strategy and culture to achieve sustainable profitability. State Street focused on the need for meaningful corporate culture as a significant driver of intangible value and a company's ability to execute its long-term strategy. So let's dive into the BlackRock letter. BlackRock's letter states a company must first begin with a clear embodiment of its purpose and its business model and corporate strategy. Purpose is a company's fundamental reason for being, what it does every day to create value for its stakeholders. The letter states that purpose guides culture, provides a framework for consistent decision-making, and ultimately helps sustain long-term financial returns for shareholders. BlackRock goes on to say that profits are in no way inconsistent with purpose. It asserts that profits and purpose are inextricably linked. Profits are essential as a company is to effectively serve all of its stakeholders over time. Similarly, when a company truly understands and expresses its purpose, it functions with a focus and strategic discipline that drive long-term profitability. Next, BlackRock tells companies that the world needs their leadership. Stakeholders are increasingly pushing companies to wade into sensitive social and political issues, especially as they see governments failing to do so. As divisiveness continues to deepen, companies must demonstrate their commitments to the countries, regions, and communities where they operate. BlackRock focused in particular on retirement as an area where companies must reestablish their traditional leadership role. For most of the 20th century, it was commonplace for employers to take on the responsibility of helping their employees navigate retirement. In the U.S., the shift to defined contribution plans changed the structure of that responsibility, leaving too many workers unprepared. This lack of preparedness for retirement has fueled anxiety and fear and undermines productivity in the workplace. BlackRock calls companies to embrace a greater responsibility in helping workers navigate retirement, lending their expertise and capacity for innovation to solve this immense problem. In doing so, companies will create a more stable and engaged workforce while also building a more economically secure population in the locations where they operate. BlackRock next focuses on the dynamic of the rising millennial generation. Its letter states that the companies that fulfill their purpose and responsibilities to their stakeholders are more successful over the long term, whereas companies that ignore them stumble and fail. This dynamic is becoming increasingly apparent as the public holds companies to more exacting standards, and it will continue to accelerate as millennials, who currently represent 35% of the workforce, express new expectations of the companies they work for, buy from, and invest in. With unemployment improving across the globe, employees, not just shareholders, can and will have a say in defining a company's purpose and priorities. Over the past year, we've seen some of the world's most skilled employees stage walkouts and participate in contentious town halls, expressing their perspective on the importance of corporate purpose. These occurrences are only expected to increase as millennials and even younger generations rise to increasingly senior positions in business. In a recent survey by Deloitte, millennial workers were asked what the primary purpose of business should be. 63% more of them said improving society than said generating profit. Also, in years to come, the sentiments of the millennial and younger generations will drive not only their decisions as employees, but also as investors. We're embarking on the world's largest transfer of wealth in history, $24 trillion, and that's trillion with a T, from baby boomers to millennials. As wealth shifts and investing preferences change, environmental, social, and governance issues will become increasingly material to corporate valuations. Finally, BlackRock laid out its investment stewardship engagement priorities for 2019 in its letter as governance, including a company's approach to board diversity, corporate strategy and capital allocation, compensation that promotes long-termism, environmental risks and opportunities, and human capital management. These priorities reflect BlackRock's commitment to engaging around issues that influence a company's prospects for the long term. In these engagements, BlackRock seeks to understand how a company's purpose informs its strategy and culture to underpin sustainable financial performance. BlackRock's focus is on a company's strategy for achieving long-term growth, not focusing on day-to-day operations. And BlackRock believes these engagements are for year-round dialogues, not only during the proxy season. We'll now turn to the State Street letter. State Street's letter this year focused on corporate culture as one of the many growing and tangible value drivers that affect a company's ability to execute its long-term strategy. So what is corporate culture? State Street says that corporate culture encompasses a broad range of shared attitudes shaping the behaviors of individuals as a group across an organization. It allows employees to identify with their organization and differentiates companies from competitors. And corporate culture is closely associated with human capital management. Corporate culture is critical to the long-term success of a company. Researchers have documented in the United States more value is driven by intangible rather than tangible assets. The global accounting firm of Ernst & Young recently found that intangible assets such as culture average 52% of an organization's market value, and in some sectors as much as 90% of market value. Investors and regulators alike are noticing that flawed corporate culture has resulted in high-profile cases of excessive risk-taking or unethical behaviors that negatively impact long-term performance. Despite the importance of corporate culture, State Street found that few directors can adequately articulate a company's culture and demonstrate how they oversee and influence change when necessary. They believe that's partly because corporate culture as an intangible asset is difficult to measure. When aligned with long-term strategy, corporate culture can enable organizations to achieve their goals and differentiate them from competitors. When misaligned with long-term strategy, corporate culture can hinder performance. While senior management plays an instrumental role in defining, shaping, and managing corporate culture, the board's role is important in assessing and monitoring corporate culture. However, State Street found that boards sometimes fail to adequately ensure that the current corporate culture aligns with corporate strategy. Based on insights gleaned from years of engagement, State Street has developed a framework to help guide directors and senior management through the process of aligning corporate culture with corporate strategy. The three-part framework involves, first, comparative analysis, which is conducting an analysis to determine if a company's culture and strategy are aligned. Next, implementation, implementing mechanisms to influence and assess progress. And last, reporting, improving reporting that can help directors discuss their role in influencing and monitoring corporate culture. More details on this framework can be found in the attachment to the State Street letter, which is available online. Finally, in its letter, State Street stated that it'll focus on corporate culture as a priority engagement topic in 2019. It will call on boards to proactively review and monitor corporate culture, evaluate its alignment with strategy, and incentivize management to take corrective action if necessary. Finally, given growing investor interest in this area, directors and senior management should prepare to discuss the management of human capital in the context of corporate culture as a driver of long-term value. When engaging with directors and management on corporate culture, State Street said that it seeks to understand whether directors can articulate the current corporate culture, what the board values about the current culture, including strengths and areas for improvement, how senior management is influencing or affecting change in corporate culture, and how the board is monitoring progress. The takeaways from this are really knowing your investor base and understanding their expectations and priorities. On a practical level, that ideally results in taking investor concerns into consideration when crafting disclosures, ESG reports, investor day presentations, analyst calls, and other forums for public interaction. But it also means that companies ought to be thoughtful in their governance roadshows and tailor their presentations to what they know individual investors are most focused on. And specifically, if you're engaging with BlackRock and State Street in 2019, be prepared to discuss corporate purpose and culture and their alignment with long-term strategy. This preparation may and perhaps should involve a company taking a closer look at its stated purpose and its desired versus actual culture with the involvement of both management and the board. These concepts should continue to be addressed on an ongoing basis as part of the company's larger discussion of long-term strategy. That's all I have for today. Thank you.
Thank you, Nova. Up next is Erin Berquist, an associate in our Richmond office. Erin focuses her practice on several areas of corporate law, including securities compliance and capital markets. Erin will discuss diversity disclosures, including a new C&DI released by the SEC on this topic. Thanks, Erin.
Thanks, Katie. So today I'm going to be discussing a new C&DI that was issued by the SEC, recent trends in board diversity, Reg SK items 401 and 407, the impact that this will have on proxy statement disclosures, and a few congressional developments regarding diversity. So first, kind of just looking at the recent trends in board diversity, generally investors favor gender-diverse boards. So the U.S. board study, the Board Diversity Review, found that during 2017 and 2018 proxy seasons, investors increasingly targeted companies with little or no female representation on their boards, citing reasons of equality, good corporate governance, and enhanced long-term company performance. Increased investor engagement on the topic appears to have prompted many boards to add one or more women directors to their ranks over the past 2 years. And when boards fail to respond to such engagement, a number of large investors have cast votes against directors. Some studies have seen a positive correlation between board gender diversity and company performance, because women present unique skill sets and attributes. One study found that women had a lot better skill sets related to audit, strategic planning, legal, government, and human resources, to name a few. Additionally, PwC's 2018 Annual Corporate Directors Survey found that 94% of board directors indicated that a diverse board brings unique perspectives, 84% responded that diversity enhances performance, and 91% stated that their boards are taking steps to increase diversity. Finally, gender-diverse boards are becoming the norm. The 2017 U.S. Board Study Board Diversity Review found that 99% of firms in the S&P 500 had at least one female member on their board, and as of September 2018, only 3 companies in the S&P 500 did not have a female board member. Some more trends. Heidrick & Struggles Board Monitor Report in July 2018 found that women filled 38% of all newly appointed independent board seats in Fortune 500 companies in 2017. And in 2017, overall, women occupied about 1/5 of Fortune 500 company board seats. This was the largest percentage of women since the data was first tracked in 2009, and the financial services and consumer sectors appointed the most women directors in 2017. Also, 40% of first-time directors were women. Parity is expected for women with men for new appointments by probably 2025. Additionally, California has recently passed a board diversity law that requires publicly traded companies incorporated or headquartered in California to have at least one female director on their boards by the end of 2019, and by the end of 2021, companies must have at least one woman on boards of 4 or less members, 2 women on boards of 5 members or more, and 3 women on boards of 6 or more members. This is the first state to mandate women presence on boards, and they use a broad definition of publicly traded companies here, so it's really any company whose outstanding shares are listed on a major U.S. stock exchange. And as far as incorporated or headquartered, it's just any company that has a principal executive office in California that is identified in their annual report with the SEC. This law has also come under some legal challenges on equal protection grounds, so we're not really sure where that's going to end up, but there could be some challenges due to the creation of an express gender classification, which could be seen as unconstitutional gender quota requirement. Finally, proxy advisory firms for their 2019 voting guidelines have touched on the diversity issue. So Glass Lewis has recommended a vote against the nominating chair of a board of directors that has no female members. They also just state that they will closely examine disclosure of board diversity considerations and other factors, including the industry, the state, and the governance profile of the company. ISS, beginning in 2020, the chair of the nominating committee and other directors on a case-by-case basis will receive an against recommendation when there are no female members on the company's board. Some mitigating factors exist there, including a firm commitment, as stated in the proxy statement, to appoint at least one female member to the board in the near term, and the presence of a female on the board at the preceding annual meeting. So now, just touching on the C&DI, so these concern regulation SK items 401E and 407C26. So 401E deals with business experience, and that basically just discussing the qualifications attributes that led to the conclusion that someone should serve as a director. And then 407 deals with nominating committee considerations and relating to company policies for considering diversity as a factor in the nominating process of directors and director nominees. So the recent C&DIs are 116.11 and 133.13. The text of both of them are the same. So the question is kind of just, in preparing item 401 disclosure related to director qualifications, certain board members or nominees have provided for inclusion in the company's disclosure certain self-identified specific diversity characteristics, such as their race, gender, ethnicity, religion, nationality, disability, sexual orientation, or cultural background. What disclosure of self-identified diversity characteristics is required under item 401, or with respect to nominees under item 407? So the answer here is that the SEC has said that they would expect that the company's discussion required by 401 would include, but not necessarily be limited to, identifying the characteristics and how they were considered. And under item 407, the SEC would expect that the discussion would include how the company considers the self-identified diversity attributes of nominees, as well as any other qualifications its diversity policy takes into account, such as diverse work experiences, military service, or socioeconomic or demographic characteristics. So the impact of these C&DIs on disclosures, primarily in proxy statements. Both of them focus on the issue of what disclosure of self-identified diversity characteristics is required. They basically provide companies with a roadmap to explain how diversity is considered in nomination decisions and other policies. The SEC has taken a broad view on what qualifies as policy. If a company considers diversity in identifying candidates, then the company has a policy for purposes of this requirement and is expected to provide disclosure about the implementation and effectiveness of its policy. Additionally, on the long-term agenda, the Division of Corporation Finance is considering recommending amendments to proxy rules requiring additional disclosure on diversity. Some more impact on disclosures. Companies should review and consider whether disclosures accurately reflect information that is provided by directors and nominees. You need to confirm that each director and nominee has expressly consented to the disclosure of these characteristics. Furthermore, consider how this information is taken into account under board diversity policies. Companies often have a wide variety of ways to evaluate directors and candidates and consider a large number of factors. Some ways that companies do address diversity disclosures include aggregated disclosure of specific diversity characteristics of their boards, or discussions of the stage of the nomination process at which diversity characteristics are considered. Some companies use skills and characteristics matrices, or else they use individualized discussion of qualifications and characteristics of specific candidates. Finally, there's been a few congressional developments on diversity disclosures. Recently, in early 2019, there was the introduction of the Improving Corporate Governance Through Diversity Act of 2019 bill. This bill would require public companies to annually disclose race, gender, ethnicity, and veteran status of directors, nominees, and senior executive officers. Under this bill, SEC's Office of Minority and Women Inclusion would be allowed to publish best practices for compliance with the disclosure rules, create an advisory council requiring formal reporting, public accessibility, and oversight principles, and solicit public comment on its best practices publication. The bill has the support of the NAACP, the Council for Institutional Investors, and the U.S. Chamber of Commerce. So finally, just to wrap up with a few key takeaways, companies should consider updating director questionnaires to gather information from each director and nominee as to his or her self-identified diversity attributes, and also obtain express consent to disclosure. Once self-identified diversity attributes have been established, companies need to link these attributes to relevant policies to the extent that these attributes were considered in their decision-making. Need to update disclosures according to the specific company circumstances. And finally, make sure to draft new disclosures far enough in advance to allow directors and nominees time to review them to ensure that the information they provided is being accurately portrayed. Thank you.
Thank you, Erin, and also to all of our panelists today for such interesting and timely presentations. In closing, as a reminder, if we did not address your questions during the call, we will follow up with you shortly by email. And also feel free to contact us with additional questions or comments in the interim using the information displayed on your screen. Also, we invite you to join us at our next webinar and to watch for our email invitation with additional details. Thanks again for joining us today.